Well, hello everybody. My name is Beverley Frost and I have an interesting story to be told this evening. This story involves what can only be deemed as property fraud, but it's one of those aspects of law that seldom gets any airtime. Leasehold property in particular, not freehold, leasehold. What's been going on over the last 20 years is that people like myself are being redesignated as tenants. We're not, and my story is a very simple one. I bought my own property on a mortgage, which was meant to have been completed after 25 years. Well, I did it in 10. So I now hold title absolute owned leasehold, which means I've bought and paid for the lease, including the bricks and the mortar. Now, you would have thought that by doing that and buying the premises for money's worth, on a lease granted for 99 years, that I would in fact be on the home run. Actually, I'm not. I'm actually facing repossession. I have what can only be deemed as a corrupt stroke bent freeholder, who's also a managing agent. Yes, there is a conflict of interest, but this conflict of interest doesn't end on a simple note. He is my third freeholder, so that people can understand exactly what I'm saying here. Freehold means that you own the land as well as the premises, which is the bricks and the mortar. Leasehold, on the other hand, means that you've bought and paid for the lease, you own the bricks and the mortar, but you don't own the land that the premises are built on. Hence why you pay a ground rent. Your ground rent could be something as simple as £50 per annum. It may be variable, in other words, it rises. In a lot of cases they do. Mine does, it rises every 33 years. So there'll be a £50, a 75 and 100. That will encompass the three sets of 33, equals 99 years. 99 years is a standard lease, to be fair. Some leases now are anything up to 1,000 years. Well, they're lucky because the chances of them being caught out in the way that I have been literally minimised. Now, for me, over the years of my being here, and I've been here since 1st of June 92, that's when I bought the premises. Didn't move in there and then, but that's when I bought. So when it came to September 2010, finalised in December of that same year, I was very surprised that the September 2010, my freeholder had in fact gone to the Land Valuation Tribunal. Now, he is the third freeholder for me. The first one, she was only here for a couple of years. She was an elderly lady. In fact, she was the one who actually paid out for the conversion of her house, and it was a guest house in its day, so that she could create 4 flats. Now, this comprises 2 up, 2 down. Thankfully, she only ever charged ground rent and building insurance. That's all it ever was. However, when she sold the freehold, at the time, I did not purchase the freehold. With hindsight, I wish I had, because I could have done, along with the other 3 leaseholders. What happened was a managing agent took over, otherwise known as at the time she thought she was being very clever. She was married to formerly of and long story short, she pursued me to the county court. She was going for forfeiture, which is repossession of the premises, on the grounds that I hadn't paid her service charges. Well, everyone, service charges are not covered in my lease. My lease is a legal document. It is a contract. And if the lease is not specifically worded, which it isn't, then why pay? Because what you're doing is, effectively, you're paying for fresh air. Because freeholders like her use their companies to rack up as many expensive bills as they possibly can. Now, these could range from, we're going to clean the hallway or the stairs. Well, that's £500 per flat. We'll have the place, the exterior, we'll do that. We'll do the redecorating. That's a 10 grand bill. I don't think so, especially when you know full well that you can get it done for about £2,000 or £3,000 less, or even for £2,000 or £3,000, depending upon the size of your building. Building insurance, it's your call, your choice, because if you want to have your own insurance, yes, you can. Because when you hold title absolute own leasehold, by the way, little technicality of law here, it actually puts you on par with the freeholder. In fact, you're often perceived as a virtual freeholder, especially in cyberland now, as we're now becoming more familiar with the internet and how far the internet spreads. So taking into account that I then have freeholder number 2 who loses at county court, she didn't turn up. The judge, in fairness, he did leave the case open for her. However, she didn't bother to do anything with it. She didn't pursue. Why? Because she knew full well she'd lost, and lost outright too. As my solicitor pointed out at the time, the lease does not make for the charging of service charges. They're not due nor payable on account, which is what she was aiming for. So she loses. Now, this brings us from December 97, in this instance, to the January of 98. January 98, I suddenly had a letter arrive, basically from the court saying she's walked away. She's didn't bother to turn up. That's great. So there I have it. February 98, I suddenly get a piece of paper that shouldn't have been around in February 98, because this piece of paper was in fact a complete breakdown of accounts and costs from the newly appointed freeholder, who, by the way, doesn't arrive or write to me any kind of notification until January 1999. However, what does arrive in January 1999 is a letter from a company who are in fact dissolved. In fact, they were dissolved as of 2005. This letter told me that they were introducing themselves and the new freeholder being held a directorship, not just in Downside, but also in... And when you did a little bit more delving, it was quite apparent that he was also a director of a variety of other companies. So the plot started to thicken. There's a wonderful technicality of English law that states that contract is between parties A and B, not C, as that constitutes a third party equals third party disclosure. So in other words, you can sidestep an intermediary by going straight back to the source. Now, the source in this instance is they are the freeholder. Fair have addressed them as such and introduced them as such. So when I suddenly get an end of year accounts turning up telling me that the funds had been transferred from the previous agent, being as of the 28th of February 1998, and bearing in mind she had lost to me literally at county court in the January of the same year, it begs the question, what's going on? Because as far as I'm concerned, if we take into account the statute of limitations, now this act is not an act, it's a statute, makes it very clear that if you're going to try and recover or repossess property and land, you've got 12 consecutive years with which to action that recovery. If it's debts, you've got 6 years with which to act. Well, my freeholder conveniently attends the LVT in September 2010. It took him until December of the same year to actually even bother to write to me to say, oh, by the way, I'm going to the LVT and guess what? I'm going to pursue you for alleged monies. Well, these monies from the Land Valuation Tribunal, which is what the LVT stands for, went back as far as the year 2000. Now, that's amazing. You would have thought that straight away, whichever barrister or whoever was sat in chambers presiding over this, the second they're given supporting evidence that states we're pursuing you for that actual time frame, you would imagine that the respectable thing to do, because this is the golden rule, that you do unto others as you would have done unto yourself, is to put a pen through it and say, no, you can't. You can only go back for the 6 years. So 2010, September, would take you back to September 2004. But that hasn't happened. He's gone and got monies dating back to the year 2000. Now, there is a little area of law that says if you're a trust and you're acting as a trustee, that in actual fact you can pursue monies a bit longer. All right, fair enough. Well, get this. Have I ever been notified of who this trust is? No. Have I ever seen any accounts? No. Is there any supporting evidence apart from them saying we act as trustees to substantiate what they're saying? No, there isn't. I haven't had anything come through. Every time I have written to downside managing agents in the past, it's always been ignored. And the reason for it is they have a trading style. And this trading style is DMA Chartered Surveyors. They're not chartered surveyors. Yes, they are members of RICS, and speaking to those in the know, RICS have often been likened to Cowboys R Us. It's run by cowboys for cowboys. And unfortunately, the tone that they adopted with myself when I laid the facts on the table to them, making a formal complaint with supporting evidence, to be fair, was completely sidestepped and ignored. And I felt like I was being treated like an errant child. Well, I'm not. And no, I'm not a tenant. Again, the way I've been addressed through the courts is the tenant, and I'm not. I never, ever signed a tenancy agreement. I bought these premises for money's worth, in other words, on a mortgage. And that mortgage, as I say, was granted for 25 years. Only I cleared it in 10 years, which is up to me. Because if you want to clear your mortgage early, guess what? You can. Some mortgage companies will tie you in and they'll say, well, if you redeem the mortgage early, guess what? We're going to sting you. That's their prerogative. That's up to them. But if you do clear it early, it means it's yours early. That's not a problem. But my freeholder decided that it was irrelevant that he had written to me between the year 1999 up to 2010. This is the best bit, stating there are no management fees, because guess what? That comprised part of the LVT award of money. There are no service charges. Guess what? That comprised part of the monies. Building insurance. Well, this is interesting because according to the Financial Services Authority, you have to be registered with them if you're going to be dealing in building insurance. And also, according to the British underwriters for insurance, they pointed out exactly the same. Now, what they did make clear was if you are dealing in building insurance, you have to be registered with the FSA, so there's a nice little paper trail. Well, guess what? He's not. And I also contacted the Financial Ombudsman Service. I put a letter to them. Now, to be fair, the Financial Ombudsman Service wrote to me saying, we are going to look into this because what you've raised are valid legal points. You've not signed a contract with this man. Correct. How is it that you're being pursued for monies this far back? Fair question. Because, yeah, I don't understand why I was being pursued for that far back, because that's one hell of a length of time. And what is it about the fact that he's raised a credit in your name? Well, again, you see, I haven't signed a contract, so I'd like to know how he's managed to do that. Now, apparently, raising credit against the property, yes, he can do that. It's not in his interest, to be fair, to really do it, but principally and legally, yes, he can. But raising credit in my name, no, he can't. Because when it came to me looking for a loan, guess what? I got turned down. And yet, on paper, I'm actually worth whatever these premises are worth. I might only work part-time, but that's my choice. I don't have to work full-time anymore because I did all of that to get the roof over my head. This is meant to be for my retirement years or to pay for my care home fees, not me looking over my shoulder and thinking, am I going to be out of here in January? I mean, now it's December 2012 and what a Christmas I'm looking forward to. Now, going back to the context here, you've had freeholder number 1 who only ever charged the ground rent and building insurance. Freeholder number 2 who tried to charge for everything and wound up losing to me at county court. So the precedent's there. Freeholder number 3, and guess what? There was nothing ever written or notified to us leaseholders about the sale between freeholder number 2 and 3. How convenient, because she's just lost. So the last thing she wants is to pursue any more monies with myself or any of the other leaseholders, because we were all in dispute over what she was trying to charge for. So she's off. Oh, it's quite clear. She's offloaded the sale of the freehold to somebody who's as bent as you like. Subsequently, he's been very cute. He's done nothing to try and raise any, points with me in writing and address any issues that I've raised with him in writing. Whatever he's ever wanted to do, he's wanted to do it verbally. Well, I'm sorry, you can say what you like, but if it's in writing, it's meant to be cast in stone, especially if you've dated it and signed it. Now, most of the correspondence that I've received from DMA Charter Surveyors from him through the early years, as I say, it states clearly there's no management fees, there's no service charges. His building insurance wasn't worth the paper it was written on. Why? Because we've got over 30% flat roof area here. Two of the actual flats have got two flats roofs. So unless they are covered and have been noted, guess what? If anything goes wrong, an insurance company doesn't have to pay out. They're not obliged to, because you didn't notify them to tell them that there are flat roofs. That's the one thing about my lease. And all, as far as I know, all leases read the same here. What should be going on is that we should, as leaseholders, be given the choice, which we can. But of course, you know, it's only in recent years, to be fair, that I've actually found out that I can do this myself, which is what I've done. I have insured the premises independent of him, because what he was doing was putting us all in with a block policy. Now, that's fine until you have something like a dirty great hurricane hurtling through, because the next thing you know is that you've lost your roof, or the place, or worse still, you've lost part of it. Say a roof tile's come in from next door, straight through a flat roof, you're not covered. However, if the property was razed to the ground, guess what? You are. But again, as to payout, that block policy, if there's something like 100 properties and you're number 99, do you really think there's going to be much left in the kitty to sort your home out? I don't think so. Which is one of the reasons why, independent of him, in the year of 2011, myself and the other leaseholders decided to go it alone and procure our own. And we did for a fraction of the cost. He wanted something like £950 for the privilege of his building insurance, whereas we managed to get it for less than £500. And noted on the policy the two flat roofs, which is the best thing we could have done. Now, as far as I'm concerned, I'm now facing county court here in England. And county court, this is the only way that the LVT award of money can be enforced. This is in accordance with the Common Hold Leasehold Reform Act of 2002, which, by the way, I don't think is worth the paper it's written on, because it makes too many discrepancies. It keeps flitting between leasehold and tenant. In fact, out of this huge act, what you've got there is about 2 mentions of lessee and 1 mention of lessor. Yes, I have sat and actually read it. I've been an anorak. I'm glad I have, because when I read that in comparison with the leasehold for the Land Registration Act of 2002, I was actually quite stunned, because there is everything is about being a leaseholder. For people that are being hit with a Section 20 notice, this is the one where they write to you saying, guess what, we're going to paint this, do that, and these repairs are going to cost, about 30 grand. And you know full well that the actual cost of that bill is probably about 2,000 or 3,000 quid. But because of the markup involved, you know that the kind of charges they're coming after you for are horrendous. And you know they're overinflated. Well, guess what? There's a thing called the Leasehold Repairs Act. Now, I can't recall if it's 1938 or 1939. But for those over here, go and have a look, because that's how you negate the Section 20 notice. That gives you the right, as a lessee, to go and have the work done yourself. And guess what? I've done that here myself. Yes, I have supplied all the proof, the invoices, all the correspondence that says I've had the work done, because my freeholder hasn't done any work here. My former neighbour, who's now deceased, unfortunately, he lost one of his windows to a rather nasty winter storm a couple of years ago. I was the one who got billed for his window repair. And yet the lease makes it very specific that each lessee is responsible for their own windows. So how is it that I wound up being billed for his window? Because that's what's happened. Then you have other elements of this. The lease, again, being the fact that it is a contract. It is a legal document. You didn't sign airy-fairy land because you were buying it on a mortgage. Put it this way, a lender is not going to allow you to raise X amount of thousands for somewhere that you're renting, because there's nothing in it for them. Because if you default on a mortgage and it's due to, say, a base rate increase, interest rates, Well, expect them to step in and take back what's theirs. It's their investment. They were good enough to loan you the money in the first instance. So if you don't pay them back, expect them to come in and take it back. Well, that's fine. Can live with that, can accept that. But not when it's a freeholder at source or a managing agent who's been appointed by that freeholder, who then makes out that, well, you owe me money. I've charged you X, Y, Z. And by the way, none of these services exist. They seldom do. But nonetheless, there's the bill. They go to the lessee saying you owe the money. The lessee says get stuffed. So what do? They go running off to the lender, the one in whose name you hold the mortgage. Now, if you're quick enough with the mortgage company, you can write to your lender quick and say, look, I'm in dispute and these are my reasons. Don't pay them anything. They won't. They will act on your instructions. However, if you don't, what will happen is that your lender will pay out. And that money they've paid out is then saddled against your mortgage. Couple that with a base rate increase, your premiums are going up. What you may have been struggling to pay as it was, you're just not going to be able to pay them. So before you know it, within the year, you are facing repossession. That repossession order will go through. Auction houses up and down the country hold on a monthly basis literally a collection of repossessed properties. So if you have a very acute and astute bent freeholder, don't be surprised if they're the perpetrator, sat in the audience of whichever auction house it is, because they've been watching you, they've been watching that property, literally sat there waiting for the favoured lot. Your premises, which, by the way, they're going to buy for a song. And the chances of them doing it, yeah, pretty high. How do you think these people get the money in the first place? Because when you're also doubling up as a property developer, that was the bit I didn't say at the beginning, you would understand what the legalities are. So therefore, you could then increase your property portfolio for next to nothing. But of course, over a 10, 20-year period, you're now riding high. You now have all that money all for yourself or for your business, your company, your fellow directors. Or better still, how about passing it on to your next of kin, like the kids? That brings me to something that could be of interest here. If you check through your own leases, you might find the saying or a clause that states, seized of fee simple, free from encumbrances. What this actually translates as is that your property, your lease, cannot be included in your freeholder's estate for the purpose of probate. In other words, when he dies and he's made a will, your property can't be included within that, because the probate office has to give a total. If you're dealing with a property developer, it's not an unfair or an unreasonable assumption that they're going to be paying inheritance tax. In other words, they're over the 250,000 threshold. This is when they value all the properties, what the businesses are, if there's stocks and shares, so they have a final grand total. It's going to take them over that 250 mark. Therefore, if you want to be sly about this, write to the Office of Probate and inform them herewith a copy of the lease, that it states seized of fee simple and that it cannot be included within your freeholder's estate for the purpose of probate and passed on to his heirs. It's a spanner in the works waiting to happen. Obviously, this is something that doesn't come to light in the first instance. It's something that comes to light much later on. And that is that you're literally sat there legally given the two fingers salute. Because when I wrote to the Office of Probate and did exactly this, I asked them to file my letter at source, which is what they've done. And they've actually kept a certified copy of the office title deeds. They've done that too. So they know that I own not just the title deeds, but I also have the lease as well. I've got both. And both, by the way, are synonymous as one and the same. Again, do not be distracted here about being a tenant or acquiescing to being a tenant. If anyone corresponds to you and they put down tenancy, make sure they know very quickly you are a leaseholder, because what's happened over the years is that leasehold and tenants have been put in the same boat. The reason they've been put in the same boat is because of there seems to be no real understanding of the difference between rent and ground rent. Rent is usually associated with, say, a short hold tenancy, which means that every 6 months it's renewable, every 12 months it's renewable. You either pay weekly or monthly. Whereas leasehold, where you pay a ground rent, remember you do not own the land that your flat sits on, set at, say, a minuscule, say £50 per annum, which in my case it is. It's a variable ground rent because it changes every 33 years. That's an interesting point as well, variable. One of the other aspects to my story as well is the fact that I'm actually overshadowed by 2 property developments. Now, there's a thing called the Right to Light Act, 1959, based on the Prescription Act. I'm going by memory here. I think it's 1832. What this amounts to is if you own your property outright, in other words, you've cleared the mortgage, you are in front of the freeholder for any payment that results that you would be actually entitled to as a result, say, of the adjoining property that overlooks you and the reduction of your light. Because if somebody proposes to do a straightforward pull down, build a new build, what they will be looking at is a possible height increase. So you need to then work out the angle of the sun, how high the proposal of the building is going to be, and how much of the light you're going to lose. And what then happens is that it's done on a rolling scale, it's done on a percentage. You may be, depending upon how much loss of light, entitled up to 50% of compensation. How this compensation is actually paid, it's to do with the new build. Say they were going up into the attic and they'd never had attic height that overshadowed you in the past, but now they will do. These 2 flats additional, which is part of their plans, could be sold for, say, £100,000 each. Well, you could actually be entitled to, say, £50,000 per flat. I'm not saying you would, as I say, because there's a lot of mathematics involved. But even a percentage of that 100,000, prospectively, is better than nothing. And as such, because you have cleared your mortgage, you are then actually in front of the freeholder for any payment. And I've got this on both sides. One side in particular, in fact, the loss of light, I would definitely be entitled to some kind of compensation payout. Which brings me back to the other side of me, who not that long ago, this has all happened since 2005, he did do a complete pull down and rebuild. And what this sneaky owner had decided to do as well was he went down to the planning department, he filled in his forms as he's meant to do, but when it came to the actual ground plans, he very conveniently included the driveway, which, by the way, he didn't own. I've only got access through there because what comes with this property, you have 4 flats and you have 3 garages, and we have 2 off-road parking spaces as well. Now, admittedly, with the off-road parking, it's whoever gets around there first, and obviously the 3 garages, 3 of the flats out of the 4 own one, and I'm one of those. Now, when I looked at his Ookie plans, and I realised that he'd marked in very heavy black ink the driveway, the rear forecourt, including our parking spaces, and worse still, our garages, and which, by the way, he put up for demolition. Well, I got round that. It was very simple. I put a blockade in. I now have a humongous truck park round there, and the remnants of one of my old classic cars, being a rather beaten up old Opel Manta. Yes, they are rather large cars, that they are exactly what you need in a situation like this, especially in light of the fact that just before I put this blockade in, I had caught him red-handed showing around a load of investors with his arms gesticulating wildly about how he was going to clear the rear forecourt, how he was going to do the drive up, and it would all look so plush and nice, and these garages were going, pointing at mine. I thought, no, the only way round this is to get down to the town hall now, have a look at his plans, which, by the way, are meant to be posted up in the road in the first instance. No, they weren't. In fact, the chap who I spoke to, one of the planning officers, he was the enforcement team, so I'm really sorry about this, I have to be honest. He said, but I went looking for those plans and I couldn't find them. He said, I don't know what you're going to do. I said, well, I do, and hence the blockade is still there. I ran him out of time, so he cannot do anything now about the rear. His access, to be fair, because I have a copy of the office copy of the title deeds for his place, and it states there in black and white that the access was in fact run out. So I think it was either in 1988 or 1989. However, in light of that, back in 95, with freeholder number 2, she decided she was going to try the same trick. Not so much that she wanted to put the garages up for demolition or any of that, but what she was after was for the 4 flats here to contribute to the upkeep and the maintenance of the drive. Problem, there's nothing in the lease that states we have to get involved with any kind of constructional works outside of our own jurisdiction. And unfortunately, that driveway's got nothing to do with us apart from access. There's nothing in the leases that says we have to pay any kind of maintenance towards its upkeep. So I contacted the actual owner of the drive, which is the other side, the other property. They contacted me. They were brilliant. We can confirm we own that driveway. It is ours. It serves our 4 garages at the rear, which it does. And number 20 only has access through there to serve their 3 garages. As I say, of which I own one of them. So in a nutshell, freeholder number 2 has tried to pull a fast one. It backfired. As I say, it resulted in county court proceedings in 97. She didn't bother turning up, so she lost by default. And then, very conveniently, the freehold is then sold without there being any contact made to the lessees. Now, freeholder number 3, as I say, is as corrupt as you like, because when it came to him coming on the scene in 99, writing to me in the January of that year, he did not action the recovery of any debts. In fact, it's not until September 2010 that he does try to do anything, by which point he's not notifying me through the LVT. No, he's notifying my neighbour downstairs. And the worst thing about this is that he also has a presiding overview at the East Sussex Land Valuation Tribunal. He's there as a manager-receiver. So what he's doing is he's liaising between disputing parties. That's not very good. That's a conflict of interest. And I actually put this to the LVT at the time. It fell on deaf ears. A lone barrister sat in chambers on the first instance said, you didn't send a defence bundle. Yeah, I did. So I sent a second. That was not received. So I hand-delivered the third within the alleged allotted time frame for appeal. Guess what? It was dismissed, frivolous and vexatious, and basically there's no right to appeal. You can't do anything, which left me completely scuppered, as I had sent supporting evidence. I'd given it in hand, had a receipt to say, look, this is my defence bundle. It was all handwritten, it wasn't typed, because at the time I didn't have access to using a laptop or being able to go down the internet cafe, because I knew how many hours this was going to take to type stuff out. So I did the whole thing by hand. That was no mean feat. All the photocopying, it was all in date format, so it was legible and it was easy enough to follow. But as I say, it was all dismissed, frivolous and vexatious. Why? Because I probably pointed out a few home truths, especially when it came to like the statutes. The man was out of time. However, it was all ignored. So that is what happened then. That brings us up to January 2011. Now come December 2011, I'm in county court. Why? Because he's going for repossession. He wants forfeiture. And forfeiture, in accordance with the old acts and the old statutes, basically means you have to be convicted of some crime. Well, I haven't been convicted of any crime. I own the place. It's mine. I've bought and paid for it. When it comes to any maintenance or any kind of repairs, I've had it done myself. I've been using the same appointed workman for the past 20 years, and I have absolutely no problem with the man's workmanship. A leak in the hallway back in 99. He sorted that out for me. Then there's the rumpus over the front door. This front door, by the way, is a communal door, but it only serves 2 flats. So we don't fall in 100% with all the latest fire regs. Why? Because it's only 2 flats, and there are only 2 people living here. So therefore, how can somebody say, oh, we've got to comply with all the latest fire regs, it's going to cost this, it's going to cost that. Guess what? We're going to completely revamp your hallway. This is no different to you being at home, walking upstairs to the bathroom or downstairs to the kitchen. It's exactly the same height ratio because it's a converted house. But nonetheless, his proposal is wanted security lighting in. He wanted to put in a nice new cable straight from the road down the path, from the front of the house. And very conveniently, on my second outing at County Court, 2 hours before I'm due in, he sends down an innocent workman to do an assessment on our front path to straighten it out. Guys, we have crazy paving. It's meant to be uneven. And that's been there since this place was built. And I'm taking you back here to the 1940s. So how can you possibly want to straighten out a pathway when there's nothing to be straightened, as it's meant to be uneven? But of course, what he hadn't told me about at that time, and I only got this through the new owner of Flat 2 here, was the fact that he wanted to lay on his electric from the road. He wanted to install an electric meter. He wanted to install security lighting. And the list goes on. Now, none of us here have been given any notification or heads up. Only he has. It hasn't been enforced. However, my being due back in County Court in January of 2013, get this, apparently I'm being pursued for future costs and future works. Well, that can only mean the road being dug up, a new electric line laid on, that's going to cost, and then an electric meter and a separate electric cable in for the hallway. Because the new chap who's just bought Flat 2 made it very clear, he was told there's no electric in the hall. Well, yes, there is. He's got a light upstairs and one down in the front door where that opens, as have I. So there is electric, but it's separate, independent electric. And no, it doesn't justify having a separate meter installed and everything else that comes in on the back of it. But this is how corrupt my freeholder is. And I'm not alone here. There are a lot of other freeholders out there who are exactly the same. As far as they're concerned, the second they purchase a freehold, it means it's a licence to print. No, it doesn't. But what's happening in the courts at the moment, and this is the biggest tragedy of the lot, is that the statutes are in fact being ignored. You can stand there and say, well, I quote from whichever statute to the Act of Parliament, and you will be ignored. You will be unheard. And this is what's been going on, because all I've been so far is litigant in person. In other words, I've been trying to defend myself. Why? Because the last thing I want is to wind up with 20 grand's worth of legal costs before I've even got to worry about the other side and what they're billing me for. People like me can't afford to do this. I know of 2 other individuals out there who are being stung for £83,000 in costs and £96,000 in costs. And their story is not dissimilar to mine. They have the problem of a corrupt freeholder or an intermediary, whichever. The same scenario, fictitious prices, fictitious services, all coming under one heading, service charges. And these service charges, I'm sorry, but they're not justified. They're not needed, especially when if you've got your lease and you go through that lease, as I say, you must see whether or not you've got another clause in there. I mentioned the cease to fee simple earlier, but this is the next one. Any act of parliament or rule of law. If your lease has got that in there, you can use these acts of parliament, but the problem is being heard. What they don't like is the fact that you're going against a feudal system. Feudalism takes us back to the Middle Ages. This is all your knights in shining armour brigade. Well, allegedly. Unfortunately, what came in with the Norman conquest was at the expense of Alfred's law, which was everything that our constitution was actually based on, which is being heard, respect for people, respect for property. With the French system, it's out the window. It's minion know thy place. And unfortunately, in this county of Dorset, it's still very prevalent. You have what is known colloquially as the toll puddle mentality. Now, most people are familiar with the toll puddle martyrs and the origins and the history of the trade union movement. It did start in the north, but it was given to the south in honour and respect of these innocent men that were shipped off to Botany Bay. And all it came down to was 1, forming your own lodge, and 2, they were starving hungry and they wanted to feed themselves. They were doing a fair day's graft, they wanted a fair day's pay. It's no different to us leaseholders. We are leaseholders, we are not tenants, but we are not being heard and we are not being received as such. Why? Because of this ancient, antiquated feudal system and the thinking, the mentality that goes with it. Dorset still has a feudal system, especially in a place called Cranbourne, because at Cranbourne, the local vicar is actually chosen by the Lord of the Manor. Not everybody is aware of that. Also, we have what is known as liberties here. I'm based here in Bournemouth. We have a liberty of Holdenhurst and a liberty of Westover. And these liberties, again, tie in with feudalism, because the village of Holdenhurst has its own rules, as does this tiny little strip of land not far from Bournemouth cinemas. It overlaps part of the Westover Road, hence it's called the Liberty of Westover. Westover Road took its name from that. And part of the Bournemouth Gardens, which most people seem to enjoy in the summer months. But if you've still got that in place, what's that tell you about the area? What's that tell you about the mindset? Everything here has always been about know thy place. I'm better than you, therefore shut up, put up. And how dare people like me go and buy property because we're peasants? That's the mentality. That's what you're going up against. And Bournemouth County Court is notorious for this, especially from a single woman's perspective. Who the hell are you to even consider backing the system? Because you're a woman alone. Really? Take a look at the origins and the history of Harrison House in Dorchester. That's an eye-opener. That'll give you a very big insight as to why the Bournemouth courts are literally a law unto themselves, especially if you're a woman of means. They don't go after every woman. What they go after are those women who are educated and who own property or have financial assistance, be it bank accounts or annuities, trusts, shares, whatever. That is what they hone in on, because they don't like the fact that you are going to wind up with power. And that's what I think you're looking at in this area. And I think personally, if you expand on that and encompass the rest of the country, because in England you still have this feudal system, but you don't have it in Scotland. In Scotland, you don't have the leasehold fiasco that you have in England. But unfortunately, until people realise how they are being fiddled and why they are being fiddled and being prepared to actually break the mould, nothing's really going to change. The only way I can see forward is to actually take a class action if it's possible. I know in America they have class actions. I don't know whether anybody watching this may well consider thinking about a class action that perhaps us English crowd could use and taking it to the European Court of Human Rights, because that's about the only place left for us, because the Supreme Court isn't going to step in. And I know people that have been up to the High Court, they've actually had all their paperwork, everything's there is in order to actually say, look, this is the proof, I've been granted this, it's been voided, pen through it. Suddenly there's no right to appeal. Bundles are being destroyed without you being told. So if there was something that you were relying on, thinking, well, I'll go and collect the bundle, your bundle's not there. They've burnt it. That's gone. Notes that to be fair, that the judges are making, they're not in the folders or the files, because you might be able to say, well, actually, if I can refer you back to whichever judge and you know which court hearing it was at, if you look in the notes, there'll be whatever. No, there's none of that. There's no continuity. And that's another thing, you see, without having the same judge from the outset, there is no continuity. So if you had the same judge throughout, he'd be able to see the beginning, the middle and the end. Now as it stands, the only recourse that people can now look at is, besides the class action coming together as collectively, it's a wonderful, wonderful thing that I only found out very recently, known as taxing the fees. Now, taxing masters are the, if you like, the law when it comes to finance, overseeing all your solicitors and your barristers. Now, the learned colleague brigade, being the solicitors and barristers, loathe the taxing master. Why? Because if a corrupt or someone of that persuasion, solicitor or barrister, sits there and makes out, well, that phone call was, 10 minutes? I'll charge 50 quid for that. Taxing master might well look at that and say, no, it's only worth 20 quid. Sorry. Oh, photocopying. Well, if I charged them, say, £1.50 a page, whereas everywhere else on the high street is like between 5 and 10p. But because he's a law firm, taxi masters say, no, it's only worth 30p. So his costs straight away are then investigated. So out of a prospective, say, £10,000 bill, you now wind up with, say, 3,000. There is a fee to be paid, to be fair, but you don't pay that until the conclusion of the investigation. And it's either 6 or 8% of whatever the final bottom base rate is, what that balance is. So that is one get-out clause. But for that to be enacted, you've got to go through all the different actions against you, unfortunately, and that's going to create so much stress. But what needs to be done in the very first instance is being listened to in the first instance. As I say, I am being billed as well for a company that is now dissolved. How? Very sneakily at County Court, an earlier invoice is submitted from the year 1999. And the company in question, now, I already had the work done. I was given notice back in 99 that there was a major leak in the hallway and that the work needed to be done. So I had the work done at a fraction of the cost. I did write to him at the opposition, my freeholder. I told him that straight. The work's been done. He even had the audacity to write to me in the September of 99 telling me that all funds had been transferred from the previous company and that, in fact, the balance now read nil. So in actual fact, this alleged invoice from 1999 was completely defunct because he's already written to me telling me that the balance transferred was nil. Then come the year 2000, I get a correspondence from him saying there are no management fees, and if we have charged any in error, sorry, we're reimbursing you. Great word that. Does that mean that there was a bank account? Because I tell you what, I haven't seen any bank account. I've got no idea about any accounts, in whose name, how much is in there, and what it's for. And worse still, from the year 2000 up until this year, I have not been sent any end-of-year accounts, period. The only way I've gained access to any accounts is through my neighbours. They've given me copies of their paperwork, to be fair, and said, here, read this. That's the only way I've been able to stay in front. Unfortunately, there seems to be too much of this going on, but the worst blag of the lot is that a leaseholder is being deemed as a tenant. Okay, if I was going to do a summary here, I'll keep it brief. In essence, this is all about residential leasehold property fraud. And when I say fraud, I'm talking criminal, not civil. However, the courts, unfortunately, again, keep stating, oh, this is only a civil matter. Actually, it's not. It's criminal. Because if you bought and paid for something and you've bought it for money's worth, it becomes yours. So for somebody to come along from an unregulated institution stroke body, which I'm afraid is the case with a lot of these managing companies, they are completely unregulated, for them to make the service charges up as they go along. We're talking spurious accounting and fictitious charges. They're effectively charging for fresh air. However, all the stack of cards is in their favour and not in the favour of the lessee, which is unfortunately the case with myself and a lot of others out there. And if I was to just say one major point here, abolish residential leasehold property. I'd like to speak to others who are in the same boat as me, and I would like, if possible, to get some kind of collective group together to try and not do this through the English courts, but see if we can come up with a plan that goes to the European courts, because unfortunately leasehold doesn't exist anywhere else. It is only over here in England. Scotland doesn't have it anymore. They've got rid of it. And this feudal system is the last thing anybody wants to be going back to. This should not be about minion know thy place. This is supposed to be 2012, not 1212. And I know there's a few out there saying, well, a lot of London, a lot of the big counties in the country, they're all leasehold. Yeah, but there is a big difference between leasehold property and somebody leasing a farm. Yeah, that's gone in, say, classed as a tithe property. It goes in with the job. This isn't about that. This is about our homes, not a business, our homes. What we would like, people to accept, that when we come home from finishing work, we close the front door, we sit down, we have our tea, because it's our home, our cooker, our front door, instead of being dictated to as if we're naughty little children who should know better. So if you are in the same boat as me, or have been in the same boat as me, I do want to hear from you. And it's bellyjane@yahoo.com.